a little to the beginning, because Mr. David already presented a few views of best interests of the child, and we will return back. So today, the principle of the best interest of the child is a fundamental principle of children's law, an area where law is intertwined with the child's life. The principle of the best interest of the child is one of the four overarching guiding principles on children's rights. And from beginning, the Article 3 of the UN Convention stated that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be a primary consideration. The concept of the best interest of the child was already contained in the Geneva Declaration of the Rights of the Child of 1959, where Principle 2 stipulated that in the laws adopted for the protection of the child, the best interest of the child should be a primary consideration. By the present Declaration of the Rights of the Child, commonly known as the Declaration of Geneva, men and women of all nations recognize that mankind owes to the child the best that it has to give, declare and accept it as their duty, that beyond and above all considerations of race, nationality, and creed. The UN Convention on the Rights of the Child was also followed by the Charter of Fundamental Rights of the European Union, which addresses the rights of children in Article 24. It stipulates that children have the right to the necessary protection and care to ensure their well-being, and that all measures of public bodies or private institutions concerning children must take into account the best interest of the child. Mention should also be made of the European Convention on the Exercise of Children's Rights, which aims to promote their rights for the benefit of children, recognize their procedural rights, and to enable them to exercise those rights by themselves or through others. A special reference is in Article number 6. In proceedings affecting a child, the judicial authority, before taking a decision, shall consider whether it has sufficient information at its disposal in order to take a decision in the best interest of the child, and where necessary, it shall obtain further information, in particular from the holders of parental responsibilities. Consult the child in person in appropriate cases, allow the child to express his or her views, and give due weight to the child, to the views expressed by the child. Slovenian Family Code, accepted in 2017, brought one of the key reforms, and this is the possibility of a divorce by a notary act, which is only possible under the Family Code if the spouses do not have a joint child over whom they have parental care. The legislator thus retained the primacy of jurisdiction in matrimonial matters solely for the courts where a child is involved. Namely, the court is obliged to examine of its own motion whether the care, upbringing, child maintenance, and contact regulation after the divorce of the parents is in accordance with the best interests of the child. Article 7 of the Slovenian Family Code states, parents shall take care of the best interest of the child in all activities related to the child. Children are brought up with respect for their person, individuality, and dignity. Parents have priority over all others in the care and the responsibility for the benefit of the child. The principle of the best interest of the child thus represents a fundamental starting point in all vertical relations or activities related to the child carried out by state bodies. However, the best interest of the child must also be a fundamental guide in horizontal relations, in the relations between parents and children. The notion of child benefit, which must be the basic guideline in all matters concerning the child, is not defined in our positive legislation. It is a legal standard, the content of which must be sought in each case separately. The only starting point is the starting point from previously mentioned Article number 7 of Slovenian Code. The performance of parental duties must therefore be in the best interest of the child. The legal standard is individually adaptable and traceable to the needs of each child. In order to be able to give the most optimal contact to this legal standard, in any case, it is necessary to take into account all the circumstances of the individual case. The Slovenian court has a wide discretion in defining the content of this legal standard. In practice, it can use a number of subjective and objective reasons that have developed over the years in case law. The court must also follow the principle of proportionality, as the exercise of parental care and obligations and rights arising from it primarily belong to the parents, like we said before, who exercise them in accordance with the principle of autonomy. They have priority over all others in the exercise of parental care. Anyone who disagrees, either a natural person or a legal person, must challenge this legal presumption and prove it to the contrary with an appropriate standard of proof. Current short-term as well as long-term benefits should be considered when assessing what benefits a child. As a long-term benefit of the child, the court defined the ability of the parent to train the minor child for independent living and to provide him with such development that he will develop into a successful and responsible person. In assessing the best interests of the child, we can therefore speak of a subjective, discretionary test, which takes into account all the circumstances that affect the child in a particular case. The principle of children's benefits is a value criterion of each user, whether center for social work, which can be an individual or a group. The living environment is very crucial for the child's further development. The preamble to the UN Convention on the Rights of the Child states that the family forms a fundamental social group and a natural environment for the development and well-being of children, and the child must grow up in a family environment in an atmosphere of happiness, love, and understanding for the full and harmonious development of his personality. The child stay in a disordered home environment leads to the harm of children at all levels of functioning. The social and family environment created by the child's relatives, classmates, and friends are important for the child, as it influences the development of his social competencies. The child's age is crucial in defining a child's social environment. In the case of a younger child, for example, 2 years old, his social environment is primarily a family environment. The court, in one decision of Superior Court of Ljubljana, defined the relocation of the child from Slovenia to England as an important step for him, as not only would the school change, but the relocation of the child would change his entire social environment, because the child is older. A change in schooling can cause the child emotional problems or stress and crucially influence his sense of security. Parents are given the opportunity to agree on their own. If the parents cannot agree on their own, despite the help of a social work center or a mediator, the court decides which must choose the option for which there are several reasons. These are objective and subjective, and as already mentioned, they are legitimized by the best interests of the child. One of the fundamental rights of the child is also the right of the child to express an opinion, which is covered by Article 12 of the UN Convention. State parties shall ensure that the child who is able to form his or her own views has the right to express them freely in all matters relating to him or her. The weight of the opinions expressed is judged according to the child's age and maturity. In particular, the child must be able to be heard in any judicial or administrative proceedings concerning him. The principle of the best interest of the child therefore dictates the active involvement of the child in the planning of his or her activities and the decisions that concern him or her. The right to express an opinion does not necessarily mean the right to decide, which represents the highest possible degree of autonomy. However, it should not be overlooked that the right to decide also possesses a certain danger, as it also means the right to make their own mistakes. A child's desire and benefit are not synonymous. What is the best interest of the child is a legal concept. This must be filled with content in each case, like we said before. In one case, the Superior Court of Ljubljana has taken over an interim regulatory injunction, which is always limited to emergency, where from the point of view of ensuring the best interest of the child, the actual situation is such that the child is at risk of violence, of irreparable harm, and the interim injunction must protect child's situation. In this given situation, in the particular case, this is a case when an interim injunction has permanently infringed the right of the opposing party to contact the child, and such a decision is contrary to the best interest of the child in the event of the alleged indoctrination of the child. The mere desire to extend contacts, which are otherwise carried out regularly, is not a reason for issuing a temporary order on contacts, which is one of the measures to protect the interests of the children and is issued only in case of proven threat to the child. Due to the fact, which was considered in another decision of the court, due to the fact that otherwise regular and successful contacts do not last as long as the applicant and probably also the child wants, the child's benefit is not so endangered that immediate state intervention in issuing interim injunctions must be necessary. In determining the maintenance obligation of the defendant, the court of first instance proceeded from the correct substantive starting points, which it found in the previously valid family code in Slovenia. This is determined according to the needs of the beneficiary and the material and gainful capacity of the debtor. However, in assessing maintenance, the court must take into account the best interests of the child so that the maintenance is appropriate to ensure the successful physical as well as mental development of the children. However, the court may not be run by a mathematical or a chisel approach, namely this calculated approximation of the costs necessary to provide the living conditions necessary for the child's development. Therefore, the court of first instance correctly re-established the contacts between junior child and father in accordance with the child's wishes, which is undoubtedly the best interest of the child. And the father's right to contact with the child must be subordinated to this, bearing in mind that father-daughter contact must be established. The court of first instance limited or redefined them to a lesser extent, thus still ensuring that the child was properly involved in the life of the opposing party, in this case, the father. The court issues an interim injunction if it is probable the child is in danger. A child is in danger, according to the judicial practice, if he or she has suffered or is very likely to suffer damage or physical or mental health or development, as this damage or the likelihood that the damage will occur is the result of parental service or omission, as states from the article of 157 of the Slovenian Family Code. The law provides a reliable basis, but that the contacts always have to be in the best interests of the child. Withdrawal of contacts is envisaged only as really the last resort. The main guideline in the process of regulating the relationship between parents and minor children is the best interests of the child. What is the best interest of the child, as we have said, is a legal concept, a legal standard. And in any case, the child's benefit includes not only the benefit of the person up to age 18, which is short-term benefit, but also the benefit that will be shown in adulthood, long-term benefit. What was this consideration also is one of the cases of the Superior Court of Ljubljana. And maybe to see a little the decision of the order of the Court of EU, the referring court states that the Judicatoria Buftea made its ruling taking into consideration the best interest of the child who has been living in Romania with her mother since the end of 2013, where she attends a French school and is well integrated in her environment. In terms of both language and culture, the child's strongest links were with Romania. The existence of a particular connection within the meaning of Article 15 of the Council regulation does not necessarily prejudge whether a court that other member state is better placed to hear the case for the purposes of that provision, or if it is, whether the transfer of the case to that other court is in the best interest of the child. There are so many factors to consider according to the decisions of the court, and I have tried to present to you only a few of them. Thank you.